The senator from Arkansas is recognized.
Mr. President, I oppose passage of the Inspector General Access Act. This bill or similar versions of it have been around for at least a decade now. To my knowledge, the Judiciary Committee hasn't had a hearing on this specific issue. Certainly haven't had one this year. As my colleagues have said, this bill has bipartisan support, and they have a principled position on the bill. I think the senator from Illinois pointed out that he supports the bill now that Merrick Garland is the Attorney General, just like the senator from Utah supported it when Bill Barr was the Attorney General, just like the senator from Iowa supported it when Bill Barr was the Attorney General. So it is true it has bipartisan support, but bipartisanship can cut another way as well. To my knowledge, every Attorney General, both Democrat and Republican, has opposed this bill since the very beginning of the Inspector General for the Department of Justice. Both the senator from Illinois and the senator from Utah used the word loophole, a loophole that the Inspector General can't investigate attorneys in the Department of Justice. That implies it was an unintended consequence. That's simply not the case. In 1988, when Congress created the Inspector General for the Department of Justice, Congress had detailed negotiations with the Department of Justice under the leadership of Attorney General Thornburgh, and they reached a compromise to keep investigations of allegations of attorney professional misconduct within the responsibility of the Office of Professional Responsibility. In 2007, Eric Holder, not someone whom I usually cite as an authority, after he had been the Deputy Attorney General, called an earlier version of this bill deleterious and unnecessary. And he said he believed strongly that it would create additional opportunities for improper political concerns to influence law enforcement decisions. In other words, Eric Holder thought that the bill would compound the problem it purported to address. In 2017, the Department of Justice once again articulated similar concerns with the bill, and just yesterday I can relay that the esteemed Judge Michael Mukasey, also a former Attorney General, said that he opposed the expansion of Inspector General authority into allegations of attorney professional misconduct, which has always been handled competently by the Office of Professional Responsibility. Judge Mukasey also relayed that he'd be happy to testify at a hearing at a later date on such legislation. I share some of those same concerns raised about this bill, and I think at the very least that we should have a hearing into what would be a significant change in the way the department polices allegations of attorney misconduct to study its relevance and its impact. I want to note that the Office of Professional Responsibility historically has conducted its investigations with integrity and competence. I did not hear any allegations to the contrary today either. That's in part because it's composed of attorneys, both former prosecutors and former defense attorneys, who have decades of experience and special expertise in legal ethics rules and the many complicated decisions any department attorney makes in the process of charging grand jury proceedings or jury trials. The Inspector General and his investigators simply do not have that expertise. The Inspector General is charged with investigating waste, fraud, and abuse. We also heard some today about independence and alleged conflicts of interest. I have to say I'm also concerned that this bill would create a serious conflict of interest itself if the Inspector General is given broad authority to investigate allegations of attorney professional misconduct. The Inspector General can and does refer criminal matters to department prosecutors. Well, let's say a prosecutor declines to prosecute one of these referrals, and an Inspector General could then come up with any reason to investigate that prosecutor. I think we all agree that the determination of who will be prosecuted or not be prosecuted lies with, indeed must constitutionally lie with, the Attorney General, and that the Inspector General should not be able to influence who is prosecuted or not prosecuted with the looming threat of potential investigation. I, of course, as the senator from Iowa said, do not want to see government of the bureaucrats, but I would point out that the Inspector General is a bureaucrat. The Attorney General is a politically accountable officer of the United States. I also have concerns that this bill could empower criminals. Criminals could additionally use the Inspector General to try to harass federal prosecutors by making them targets of unfounded investigations. With the wrong Inspector General, with the wrong political climate, a career prosecutor could be pressured by left-wing jailbreak advocates into dropping cases against violent criminals, pursuing cases against police officers who broke no laws. It's not surprising that this bill is supported by left-wing groups such as the ACLU, Demand Progress, and the Brennan Center. The Inspector General could easily weaponize professional misconduct investigations also to defeat anti-crime policies that an executive branch chooses to pursue. Imagine, for instance, an Inspector General who refused to dismiss allegations of racism when a U.S. Attorney's Office simply chooses to prioritize gun prosecutions in high-crime areas. Such investigations would have a chilling effect, of course, on other offices prioritizing similar prosecutions. We also heard some about transparency, but I would note that this bill does not necessarily provide more transparency because, just like the Office of Professional Responsibility, the Inspector General is governed by the Privacy Act, rules pertaining to grand jury materials, and court orders sealing documents. This bill would not change that. If it's punishments and sanctions that the bill is concerned about, I would also note that the Office of Professional Responsibility is not responsible for the level of discipline imposed. That falls instead to the Professional Misconduct Review Unit, a unit created by then Attorney General Eric Holder in 2014. Expansion of Inspector General jurisdiction would not change where that responsibility falls. I, of course, share concerns of my colleagues about politically motivated prosecutions or prosecutions pursued by so-called glory seekers, but I do not want to proceed down a path where we unintentionally exacerbate the very problem we're trying to solve. Therefore, Mr. President, I object.